Good afternoon, everybody. I'm going to do a quick introduction and then turn the microphone over to my colleague, Rob Roesener. So one of my points of pride is giving learning opportunities for those in planning development side. So we do Places and Faces tour. We get out on the road. We go to see places normally we don't see. And it's all to appreciate everything that Rutgers offers, right? So as a reminder, we have a three-part mission. You've heard about this. You've heard about our really interesting history from Frank Wall. You heard me try to explain the complex, right? Big institution, one president, a single accredited institution, 4 chancellors, 1,000 buildings, right? We talked about why is Rutgers so confusing from a physical perspective, right? 23 campaigns of cobbling together properties in New Brunswick alone, and then you throw in 2 campuses in Newark and Camden. So it's a big place, it's a confusing place, complicated, wonderful, love working here, but why is it we are what we are from a legal perspective? So Rob Roesener agreed to talk about this. He's going to talk about 2 pieces of, 2 laws or act that I find really important to understand, the Piluso Act and the 2013 Higher Ed Restructuring, and also case law that strengthens, Rob can explain it, but it allows us to do what we do. I think this is really fascinating. I hope you enjoy it as well. There's no PowerPoint. Rob's going to present, talk, and then take questions at the end. And we are joined by some OGC colleagues, Office of General Counsel, Rob's colleagues, who are here because this is going to be really informative. And for some of you, you should really understand this because from a land use and planning perspective, it guides what we do. So with no further introduction, with no further delay, Rob Roesener.
Hi, everybody. Thanks for coming. Hope you can hear me. I'm Rob Roesener. I'm a Deputy General Counsel in the Office of General Counsel, and yes, we have 4 folks. I lead the transactional practice group. Our office has sort of 4 main pieces, but I'm the transactional guy lead that group at least. But Dave asked me to talk about the 56 Act, which is also called the Rutgers Act, and the Piluso case mostly. But in order to understand that a little bit, I have to go into a little bit of the history of Rutgers. So I'm going to talk about 7 really sort of quick subject areas. Those are the 2 main ones. But in order to have an appreciation of the 56 Act and the AKA Rutgers Act and why it's interesting, you kind of have to have a little bit of history. So I'm going to start with that. So just some quick facts. And by the way, if you have any questions when I'm going, just jump in, ask the questions. I'm just going to speak, and I'm going to warn you up ahead of time. There's some pretty interesting pieces of writing that had happened over time that I'm going to read from because, the authors of those, who I'll talk about in a minute, are better writers and speakers than I am. So I'm just going to, and it's might be a little boring, so just bear with me when I read those provisions. But so anyway, again, Rutgers was founded in 1766, as you might all know. It's the 8th oldest college in the United States. It was originally called Queen's College, and it was a bunch of Dutch Reform settlers basically petitioned for a charter to start the college. And King George III, the king in England at the time, actually granted the charter, so it's called a royal charter. From the royal family, I guess. So it's interesting. If you think about that, Rutgers was here before the United States was a country and before New Jersey was a state. So when we argue with the state sometimes about like regulatory issues, if we can get that in, I like to say, we were here before you guys were even a state. So, and it was a private institution formed at that time, and it was governed by the Board of Trustees, which is the same Board of Trustees that exists today as one of the 2 governing boards. There's a Board of Governors, which I'm going to talk about later. And again, it was called Queen's College originally, and its sort of correlation was to King's College. King's College, does anyone know what King's College is now? And Columbia, right. King's College was formed 12 years earlier as one of the older ones from us, and became Columbia University, and then renamed Columbia, I guess, in 1912 or something, Columbia University. Interesting little factoid, Rutgers first admitted women in 1970. Columbia didn't do it until 1983. So I thought that's interesting. Anyway, after the Revolution, the American Revolution, New Jersey confirmed, and New Jersey was a state, they confirmed the Queen's College Charter in 1781. In 1825, Rutgers was renamed Rutgers College in honor of Henry Rutgers, who was a colonel in the American Revolution. And he was a donor to Queen's College. Does anyone know what he donated to Rutgers? Yep. The bell, that's right. There's only, the only two things he donated and got the the college and renamed after him was the bell that hangs in Old Queens and it still rang once in a while, and a $5,000 bond to help the school when it was faltering at that time. Now, when he died, nothing else came to Rutgers, and I guess he was a fairly wealthy guy, but nothing else came to Rutgers. So I think the university or the college at the time was expecting some more in his will, but nothing ever came. But nonetheless, we have his name. And the bell, that's right. So there's a couple of pieces of federal legislation that affect the history a little bit. In 1862, the Federal Morrill Act, which was the Land Grant Act, for those of you who don't know, that's basically the federal government gave 30,000 acres of land, usually land out west, to the states, and it was 30,000 acres per representative or senator in Congress. And the idea was for the states to use that land, either sell it or use it, and if they sold it, to invest in agricultural research and mechanical arts research. And then it was supposed to be it was the original founding, basically, of cooperative extension. So the goal of the federal government was to have this research done and impart that knowledge to the public. It was a pretty good idea. And I was wondering, why did they have so much land? And I looked online, and the National Archives says this about the Morrill Act. Much of this land had been and would continue to be taken from Native American tribes. It was ceded through treaties, agreements, and seizure. Often tribes are effectively forced to sign treaties ceding land because of the living conditions or threat of violence. In many cases, the federal government did not uphold its end of these treatises. Anyway, not so great. So we are a participant in some of that early history. But anyway, Rutgers did. The point of that act was to get education or research done, and then educate the public on what people were finding out. In 1864, 2 years later, Rutgers Scientific School, was a department of the college at the time, was named New Jersey's Land Grant College. Interesting factoid, Rutgers beat out Princeton University and another school called the Normal School in Trenton in order to get that designation. So I think that's kind of cool. Princeton actually is one of the older ones from Rutgers. And with the money that Rutgers got, we bought a 100-acre farm on the outskirts of New Brunswick from the James Nielsen estate. Anyone know Nielsen Street in New Brunswick, named after the Nielsen family? And anyway, that was the first site of the research farm. It's now Cook Campus. Other federal acts, the Smith-Lever Act in 1914 and the Hatch Act in 1887, essentially made money available to the states. And so New Jersey was basically appropriating money it was getting from the feds in support of agricultural research and cooperative extension. But New Jersey, unlike most other states, did not create a state college. They just basically used Rutgers, this private institution, to carry out these public obligations. So that's number two. So that leaves my second issue. There's some constitutional problems with that. In the late 19th century, from the late 19th century to the 1940s and 56, the state appropriations were expanding, and by 1956 it was over $10 million. And the reason that's an issue is because in 1875, which was typical across the country, all the states and the federal government amended their constitutions to ban any money going to any corporation whatsoever. And so because Rutgers was a corporation and was getting money from the state, there was this constitutional problem. And this, one of the things that I meant to say at the beginning. There's some things I have, my notes. I'm going to give it all to Liz, and if anybody's interested in reading any of this stuff after I'm done, Liz can disperse it. So thank you, Liz. But in 1975, Joseph Weintraub, who wrote the 1956 Act, which I'm going to talk about later, he was the Chief Justice of the New Jersey Supreme Court. In 75, for some reason, he wrote this memo to then President Blaustein at Rutgers, and he talked about that constitutional issue. He said, the constitutional amendment, which, by the way, was typical of constitutional amendments throughout the nation, resulted from the horrendous experience of government in supporting the infant railroad enterprise. There were huge public losses leading to constitutional bans upon public assistance for purely private enterprises. So now you have that amendment in the background, and so we have this issue. And so the memo explains how New Jersey had been appropriating money to the private entity of Rutgers without running afoul of that constitutional issue, and it's basically a contract method. And he wrote, and again, this is the long one, so bear with me. A second exception to the literal ban of the 1875 amendment was developed by the courts to meet practical demands upon government. There are some public needs which are better met by contracts with private corporations than by government action, either directly or by way of a state-owned agency. For example, the municipality desiring to provide hospital care for its indigent could not sensibly be required to construct its own hospital when such facility already existed to meet municipal need. It would make more sense to permit the municipality to contract with a private hospital for the furnishing of a specific number of beds in consideration of the payment of an annual sum. The contract was deemed by the court to provide the kind of control against gifts of state monies which would meet the objective of the 1875 prohibition on that. And so that's basically what was happening. But in 1945, and this is the third subject area I'm going to talk about, was the first time that the state actually declared still private Rutgers as the State University of New Jersey. Many people think it was 1956 when Rutgers became public that we became the state university, but actually that's not true. It was 1945, and this legislation from New Jersey at that time declared the private college of Rutgers to be the State University of New Jersey. I think it was a university by that point as well. And at that time in 45, the state actually added 5 members to the then fully private Board of Trustees as a little bit of sort of a give back to the money that was coming in. There's a section of the 1945 Act that says that the state and the Board of Trustees covenant and agree that the educational facilities of Rutgers may be utilized by the state of New Jersey as an instrumentality of public higher education, and the state will appropriate such just and reasonable sums as may be necessary to enable the trustees to maintain and to render education services heretofore and hereafter required by the state. So again, it was 45 that Rutgers finally became officially the state university, but it was still a private university. That pesky constitutional issue was still out there. And then this is another provision from the 1975 memo that Weintraub wrote. He wrote in that 1945 Act basically said there was supposed to be an annual contract each year. The state and the Board of Trustees would enter into a contract and basically say, states give us money and we'll give public education experience. But Weintraub wrote this: "The plain fact to me is that the contractual arrangement was a charade and was lacking in the kind of specificity with respect to what the state was purchasing, which one would find in an ordinary contract. What Rutgers was to do was really not described, the effect of the arrangement being simply that the state contributed an annual sum to assist the private university in meeting a public need for higher education." So, and the 45 Act left a lot of confusion. That relationship went on for another 10 years until 1956. The state was contributing money. Rutgers was using that money to build buildings, to buy equipment. There was no one was keeping track of who owned what. And so it was becoming this conglomeration of state and private. So it was sort of a bit of a mess. And the way to fix that then became the 1956 Act, which is the next topic I'm going to talk about. Instead of doing this annual contract, the Board of Trustees and the state came up with a whole new arrangement. And basically, in short, the Board of Governors was born in 1956. And so the deal is that the state would appoint more people to the Board of Governors and therefore have control. So the state has official control over the university, and the trustees would appoint some people to the Board of Governors as well. So that's what we have now today. We still have the Board of Governors and we still have the Board of Trustees. At the time, in 56, the Board of Governors was basically given all authority to run the university. They basically handled everything. The Board of Trustees had a much more limited role at this point. And again, the heart of the 56 Act is this contract. It's a very unique piece of legislation because, like all contracts, one party can't breach without the other one's consent. So if the deal of the contract gets tweaked by the state too much, the Board of Trustees can say, wait, no, we don't agree to that. And so that's their basic role today, is to sort of oversee the autonomy that Rutgers gets from this 56 Act, and to appoint, it's now 7 members of the BOG come from the Board of Trustees, and 8 members come from the state. So it's a very closely, almost even, but the state has one more, and then that solved that constitutional problem. And Weintraub's, this is the long one, so bear with me on this one. Weintraub's 75 memo talks about his role, and Weintraub wrote the 56 Act. So it's of all people who have knowledge about it, he's the guy. So this memo is pretty interesting. So he suggested, let me think, hold on a second here. The initial draft of the act said that the state would appropriate whatever monies were needed to effectuate the corporate objectives. But there's another issue, is that one legislature can't bind future legislators. So like the legislature of today can't say, hey, we're going to make sure that the state funds X dollars every year forevermore to whatever. That's not allowed either, because each succeeding legislator gets to control the budget of the year. And so he wrote, that was originally what was going to be the deal, but he suggested that the act set forth the policy and the goal of the act. So here we go. I proposed to counsel for Rutgers, who was Waldron Lord at the time, that there be no more than a declaration of policy, that adequate funds be appropriated annually, but that the private trustees be given an expanded basis for withdrawing the private funds from the proposed 1956 arrangement. The initial draft proposed of the trustees' withdrawal for rather limited reasons. I suggested that the basis be extended to the end that Rutgers would have the maximum autonomy and independence consistent with the fact that public monies were being put into the pot. It was my belief that as a practical matter, the proposed marriage could never be dissolved, but nonetheless, the withdrawal provision could protect the university from political interference and thereby further the ultimate public interest. In sum, then, we have a contractual arrangement embodied in the 56 statute, which, although surely not so precise in its terms as to resolve all problems, nonetheless provides a framework within which problems should be approached. In a very real sense, the arrangement calls for a high degree of statesmanship for the resolution of the sticky problems which are sure to arise when the amount of the appropriation remains within at least the initial control of the state and the operational control at the university. Rutgers is an instrumentality of the state and clothed with contractual guarantees. So again, it's a very important thing to keep in mind, that there's a whole lot of reasons where the trustees, if they are not happy with the contract they made in 1956, the act provides that they can take all of the trust assets that they gave to Rutgers in 56 at that time and sort of take their marbles and go home, is what we say. We call that the Nuclear Act. And that would never really, as he says, Weintraub wrote, that would never happen. It would be impossible to do it. But it just gave the trustees a lot of authority, and it gave the university a lot of autonomy compared to a lot of other state instrumentalities and agencies. So that is one key thing that makes Rutgers very unique among other state agencies, is that this weird contractual relationship in our private past gives us a lot of autonomy. So keep that in mind. It's a pretty cool thing to know. And one of my favorite provisions of the Rutgers Act basically says that all of the rights it enjoyed under its original royal charter from King George III are hereby ratified and confirmed. And so that basically its ability to carry out business as a private entity were still enabled under the 56 Act. And later on, I'm going to talk about how that breaks down. There's some examples where Rutgers is sort of a state entity and Rutgers is sort of a private entity in other examples. So we try to play it to our advantage. When we want to be private, we say we're private. When we want to be public, we say we're public. And it doesn't always go to our advantage, but I'll talk about that in a little bit. So one thing about, at the time, just a quick note, in 56, the Board of Trustees, they weren't sure that this was a legal thing to do. I mean, they have a fiduciary responsibility as the trustees of all the trust assets to make sure it sort of carries out its functions. So they actually filed a declaratory lawsuit with the court at the time to say, hey, we're doing this, is this legal? And the court said yes. And that case is Rutgers v. Richmond. And so, that's, in that case, if you're interested, it actually gives a pretty interesting history of this what I've gone through really quickly here. A recent example of the Board of Trustees, and Dave mentioned the Restructuring Act in 2012. How many of you guys were around in 2012 when we merged with UMD&J? So a lot of you, most of you probably remember what that year was like. So I guess the quick history on that is circa 2011 or 2012, President McCormick and Phil Formansky, who was the provost at the time, they met with the governor and even George Norcross, some pretty significant power brokers in the state, to discuss, because Rutgers at the time didn't have a medical school, and it was sort of, compared to our peers in the Big Ten and elsewhere, we were lacking in a lot of things because we didn't have this coveted medical school. In fact, actually in 1970 we did have a medical school, but the state took it away and created UMG&J with it. And I guess at that time the trustees or the governors must have accepted that. But back in 2012, Rutgers wanted this medical school back. It would be good for our standings and start, for statistical reasons and whatnot. And so Rutgers approached, and there was this discussion going on, and the state was interested in actually having something go on with UMG&J, because at the time there was a federal monitor involved. There had been allegations of wrongdoing basically at UMG&J. So UMG&J, as a completely state-controlled entity and with a lot of sort of political issues, which is why Rutgers is sort of insulated from this contracting, was going through trouble. But the governor at the time, and I have this Philadelphia Inquirer article, which is just fascinating. Some of you may remember that the deal that the governor wanted was that Rutgers would have to give up Rutgers Camden to Rowan University. And here's just a quick quote from the article at the time. The author was talking about what Chris Christie was saying. He cautioned that Rutgers officials can't pick and choose from the advisory board's recommendations. Either they swallow the bitter pill of turning over their Camden campus, or they lose their gains in New Brunswick. He said, I cannot believe that Rutgers University is going to turn down the opportunity to be able to get Robert Wood Johnson Medical School, the Cancer Institute, and the School of Public Health over this dispute. He said, let me make something very clear. It all happens or none of it happens. That's Christie at the time. That was very political, and that whole year, 2011, 2012, that was just one example of a lot of that. That was a big heated discussion going on around the state. You heard what the governor said. At the Rutgers Camden, the community went crazy, as they should, because they're part of the Rutgers family, and Rutgers gets to decide what we do with our family. We're in control of our destiny, not you, Mr. Governor. And so the trustees, they did their job at the time. They stepped up and said, you can't do this without our consent. We're not going to give you our consent unless we get to keep Rutgers Camden as part of Rutgers. And so the governor ultimately had to back down. He was proven wrong. And because of this 56 contract and the trustees, they actually did what was right. So a very proud moment of Rutgers and the trustees at that time. The trustees used to be 59 members, which is a pretty big board. And because of that, they agreed to a deal, and they shrunk themselves to about 42 members. Still a pretty big board, but they did give up some of themselves, but still, they still have the same authority as they used to have. All of that now gets to the Rutgers v. Piluso case. So again, if I'm going too fast or too slow, or if you have any questions, please jump in. So Rutgers v. Piluso is a really important case for us. It was a New Jersey Supreme Court case in 1972. Basically, it was litigation based on one question. Is Rutgers subject to the zoning ordinances of a host municipality? And in this case, it was Piscataway. Piluso, the guy's name in the case, was the code official in Piscataway at the time. So basically, the procedural history of the litigation was in 1971, the trial court decided for Rutgers, which had filed a motion for summary judgment. Piscataway appealed, but before the appeal was heard by the appellate division, the Supreme Court took over the case. And the factual background at the time was this. In the late 1960s, Rutgers had been expanding pretty quickly. Enrollment was shooting up, and there was some talk that New Jersey lagged the nation in providing public higher education facilities. Rutgers was going through a massive building campaign, and we wanted to build, at the time, more graduate student housing. The Piscataway ordinance limited the number of housing units to 500. We had already built the 500 units, and we wanted to build another 374. And so because it exceeded the ordinance, Rutgers first applied for building permits from Piscataway, which they denied. And then we went to the zoning board and tried to get a variance, which they denied. So then Rutgers filed a suit offensively. This is great. See Rutgers sort of defending itself. We first asked for three things: force the zoning board to issue a variance, declare the ordinance invalid, or declare Rutgers exempt from the local zoning. The trial court initially remanded it back to the town to sort of look into the ordinance issue and whatnot. But then Rutgers eventually dropped the first two issues and just went straight with a summary judgment motion to the trial court. And do y'all know what a summary judgment motion is? Yes, no. It's basically, there's no real dispute of facts. It's just a question of law. Both parties agree on what the facts are, but we dispute about what the legal outcome is. So you go and ask a judge, hey, we need you to rule as the third party on who is right here. And so we filed a summary judgment motion in 71, and the court came down on our side. We offered some interesting data. Again, in 71, the enrollment levels were about 10,000, expected to go to 19,000 by 1980. In 71, there was 1,788 grad students. Half of them were married, and that was expected to be 5,900 by 1980. all of the planned units that they were wanted to build would have been taken immediately, and they were looking for a total of 1,500 family units by 1980. So there was a big need, and the court saw it pretty quickly. The court also felt that Piscataway was trying to stop the family housing because they didn't want to build a new elementary school to educate the children of our married students. There was a lot of married students, they had children, those children would go to the Piscataway public schools. So the court jumped into the black letter law and looked at legal cases in prior history, prior legal cases, and the black letter law at the time basically is absent a waiver expressed by or necessarily inferred from the language of a state statute, a state is not amenable to the zoning regulations of its political subdivisions, and a public corporation or authority created by the state, I'll keep that in mind, created by the state, to carry out a function of the state is not bound by local zoning regulations. So the law was on Rutgers' side for the most part, and they also looked at some cases. The Turnpike Authority was a state instrumentality. It's immune from local zoning laws. There was a case prior to 71, I think it was in the 50s, where the Turnpike was being built. They wanted to build like a restaurant and a garage in the town of Bloomfield in a residential zone. Bloomfield said you can't, you need a zoning, and that the state basically, or the courts basically said no, it's a state instrumentality for the benefit of all people. The Turnpike can do it, or the Parkway can do what they want. And so, but the court in Piluso, the Supreme Court, again, they cited those cases, but they created a new type of test for assessing immunity. They didn't say just mere state ownership doesn't necessarily mean you're going to be immune. They created this 5-part test: the nature and the scope of the instrumentality seeking exemption, the kind of function or land use involved, the extent of the public interest to be served thereby, the impact of the local land use would have on the enterprise concerned, and the impact on the local interests. As they started to get into the facts, the court held, with regard to a state university, again, passing for the moment on the matter of any particular status of Rutgers, there can be little doubt that as an instrumentality of the state, performing an essential governmental function for the benefit of all the people of the state, the legislature would not intend that its growth and development should be subject to restriction or control by local land use regulations. So we won pretty handedly with that holding. But then the court kept going, and so did Piscataway in their arguments. The court said that immunity can't be completely unbridled, is the term they use. Basically, they're saying if you are a state entity and you are immune from local land use rules, you still can't be completely irrational or unreasonable. And the court case gave the example, like if the state wanted to build a big office building in downtown Trenton and didn't provide any kind of parking for off-site parking, and that was required by Trenton's ordinances, it wouldn't be really that fair if, for the state not to consider at least the local interests. So they put some language in the case that basically says we have to, that the immune instrumentality still has to listen to and deal with the locals a little bit. And this was before the municipal land use law, which came out in 1975. And so that part of the case actually became part of the municipal land use law. And so now, Dave is familiar with what we call the Section 31 review. You go and present. The nice thing is they don't have the ability to say no, but you do have to listen to them and at least be reasonable. Reasonable is a good word. The court said, as to Rutgers and the housing, it said, we failed to see the slightest vestige of unreasonableness as far as Piscataway's local interests are concerned or in any other respect. So the court was definitely on our side. The last argument Piscataway made was that this whole way that Rutgers wasn't officially a state instrumentality, it had this weird private past. And they said the 56 Act is a contract and the resulting entity is unique and shouldn't have immunity. Not a real strong argument, and the court saw through it. The court wrote, the point confuses the method of creation of Rutgers as the state university, which was by legislative contract, with the nature of the entity that resulted from the standpoint of the problem before us. So again, and then that point, the court went into a big history. The Piluso case has a really interesting history of Rutgers as well. It cites the Richmond case that I mentioned before from 1956. And then it says, the overall result of the legislative contract, therefore, is an autonomous public university, not merely a contractual relationship, or, in other words, an institution both public and private at the same time. So you have this this is the one case, or there's a couple of other cases, but where the courts of the state basically say Rutgers is this hybrid instrumentality. It's private and public at the same time. It's like, how can that be? As a lawyer, when you first get to Rutgers, you're like, this doesn't make any sense. How can it be? But it just is. We are both public and private, and it's because of our weird past. But the final holding of the case, which is a good one to read, is the whole picture demonstrates to us beyond any doubt that the legislature must be said to have it intended that the growth and development of Rutgers as a public university for the benefit of all the people of the state was not to be thwarted or restricted by local land use regulations, and that it is immune therefrom. In this respect, it is a statewide facility entitled to the same protection from local enactments as the Turnpike and the Parkway, so long as it does not act unreasonably or arbitrarily. And so now we're left with this, like, we are a hybrid instrumentality. So, and this is what I mentioned at the beginning, where I was just going to go through a couple of examples where we're state and where we want to be state, and somewhere we're private where we want to be private, and somewhere it didn't really go the way we wanted it, but we have to deal with it anyway. So I just said zoning, we're considered a state instrumentality, so we're state for purposes of zoning. I'll go through the state ones first. For property tax, we're also considered to be a state. So our property is considered state property for purposes of local property taxes. Now, a lot of private entities can also get tax exemption, local property tax exemption. Princeton University, for example, that's private. They don't pay property taxes. But the rules around privates and publics as far as tax exemption, property tax exemption, are much better for us. So it's good that we're a state in that one. Another one is court rules and limitations periods. Like there's this doctrine, nullum tempus, time does not run against the king or the state. So for purposes of like statutes of limitations, that doesn't apply to Rutgers because we're state. And so that's a good one that we're a state for. It's helpful for eminent domain. I mean, one thing when I first got here, and I guess 18 years ago now, there were some questions about people whose yards back up to the preserve, the ecological preserve on Livingston. Some of those backyards are slowly getting a little bit bigger, and they're eating up and living on our property. And there was some talk about, well, let's do something about that. And are we going to run into what's that? I need my brain's going blank on when you adverse possession. That's what it is. So when somebody takes over somebody else's property for a long enough period of time, you can actually go get legal title to it. If the real owner doesn't come along and say, hey, wait a minute, you're on my property, get off. But time doesn't run against the king or the state, so we don't have to worry about the timing issue for us, and we can take that up whenever we want. For bankruptcy law, federal law trumps state law, and so we have to sort of deal with federal law for bankrupt issues. Rutgers, the matter in that case was Rutgers can't withhold transcripts from bankruptcy filers. Here's two where we're state where it's not so great for us. One is the Open Public Records Act, and the other is the Open Public Meetings Act. It'd be ideal if we didn't have to deal with either of those, but we do have a lot of state input and a lot of state money, and because we are basically hybrid, and the Open Public Records Act law in New Jersey is very strong. If people want to see our records, they have a right to do so. If you're Princeton, no right to do so. So that would have been one that would have been nice if we were private, but we didn't win that one. Same thing with open public meetings. You have to allow the public to come and watch your meetings. You don't have to allow them to speak at them, but they at least have the ability to watch, and Rutgers does actually allow people to talk. Again, if we were Princeton or private, it would have been nicer to not have to deal with that one. Tort Claims Act is one where we're public, and that is a benefit for us because if someone files a tort claim against Rutgers, meaning if they slip or fall on our campus and they want to sue us because we were negligent in maintaining the sidewalks, the Tort Claims Act makes it harder for publics to be sued. And so that's one that's helpful for us to be state. Where we're private is procurement laws. So we don't have to follow state procurement laws. We can issue our own bids and follow our own bidding procedures. Now, mind you, we do mirror the state procurement process to some extent, but not fully. And so we are able to do our own procurement laws the way we want. We can negotiate with a bidder, even if it's detrimental to the other bidders. And if we find one, and I don't think that's allowed under state procurement rules. Where Rutgers is not entitled to 11th Amendment immunity like the state is. This is one where it would have been better if we were state, but that one went against us as a private. We're not subject to the State Contract Liability Act. Rutgers can have a jury trial in a contract dispute, unlike state entities. So that's a benefit for us from the private side. Law professors acting as private lawyers in the clinics are not subject to conflict of interest rules or OPRA. So there's one where they carved out a little piece of Rutgers that we're more private in that regard. And so I guess the biggest one from my perspective is that we're not subject to the Administrative Procedure Act. So the APA, the Administrative Procedure Act, is a massive sort of when the state agencies create new rules, they have to go through this process, and it's a long process, and there's public input. We don't have to do that. So our policies, we just create them. And so that one went to our advantage as a private. And with all that rambling, that's the end of my presentation. So is there any questions? Go ahead.
ADA, how do we fit facilities-wise with, like, say, federal regulations or the impact on state regulations?
So I think for ADA, we're a state. I mean, we would be a state, and I think I'm not sure how it breaks down between how it applies to like privates if you're opening to the public. So, but yeah, we do follow like whatever the requirements of the ADA are. So, Mr. Richter.
So I have a question. So we have trustee land, we have governor's land, but why do you still have state land that we're in control?
Good question. I mean, so that's another thing. So all of the trustee property that they purchased and owned up until 1956 is still actually owned by the trustees. And anything that Rutgers bought after that is technically owned by the Board of Governors or the institution of Rutgers. And so that often comes into play. But the state gave a lot of land to the university to use or to basically to use or do research on. And the state kept title for whatever reason. So, I mean, even though Rutgers uses and controls the land, we never got title to it. So that would be the answer as to why there's state property that's still technically owned by the state that we use. So it wouldn't fit into either trustee or governor land in that case. But I mean, I hope that history gave you some appreciation of why Rutgers is unique, and we are supposed to be autonomous. My observation over my short little 18 years has been as more state, as we go along through time, basically the state's trying to get more and more control over Rutgers, even as state support for university is going down, and that decline of state support for Rutgers is common across the country. It's been the same everywhere. And so, but it's odd, as state support goes down, their control or their wish for more control over Rutgers kind of goes up. And so the tests for the both boards really, but the Board of Trustees may be coming more frequently. And it's funny because the budget, Rutgers budget, I mean, one thing about the Act, the 56 Act, is it does say that the state's supposed to give us enough money to function properly. Well, we could argue that, like, you know, look, we're always short, and so therefore you're reneging on your contract promise to us, and so we've never actually taken that case to court and see it's because like the state does give us a lot of money. You don't want to bite the hand that feeds you too much, but on the other hand, like, it would be interesting one day to be like, all right, you promised in 1956 that contract, as valid today as it was then, the passage of time should not make it any less valid. So we're gonna say that you're not honoring your end of the bargain. I don't know how wise it would be. I don't think any leader would want to do that, but it could be something we could do. And it'd be interesting to see what the result of that would be. So there are some kind of, and the other bit about the 56 Act, that the sort of self-control or autonomy, there's a bunch of provisions that say, you know, if the state interferes with any of these types of things, the trustees can use what I said, that nuclear option, or we can take our property and go home. The trustees can, but again, that would never really happen. What it would engender was which Weintraub talked about, is the statesmanship, or this hopeful discussion between reasonable people that we could work it out. And so that was kind of the idea. And that's what we're left now, is just kind of this path of working it out with the state whenever we have disputes. But that's all I had. Hopefully any more questions. Frank?
Funny those monitor coming into UMD&J at the time when, prior to our merger, there was a big push for the Stark anti-kickback with the clinical operations. Are we still subjected to those?
Yes, because our clinical operations are all still subject to anti-kickback and Stark rules, because there's federal money going in to pay a lot of that. Like our payer mix includes insurance companies, but Medicare, Medicaid, and so those federal laws are definitely still triggered, and our operations are under that.
And then the other question I have is that one of the things, the legislation that was put forward in 2013 as a result of the merger regarding the separation with University Hospital.
Yeah.
There's a thing.
Yeah, so that was a big negotiation point, and basically, no disservice to University Hospital, but they're a money loser, and I think they're a money loser for UMD&J. Dave, you can probably speak better to that than I can. But Rutgers took over all of UMD&J's debt. So on July 1st of 2013, all of the debt that UMGNJ had, except for any debt specifically related to UMGNJ or some of the assets that did go to Rowan, that all came under Rutgers' banner. And so that's where the trustees had their hook. They were like, the trustees have the right to consent to any debt that Rutgers issues. And so because we were taking on a huge amount of debt, and actually our credit rating went down because of that, but the university agreed to do it. That's where the trustees said, you need our consent. We're not going to give you our consent unless we keep Camden. But as to the university hospital, I think the state did see that it wouldn't be fair to saddle Rutgers with all the debt we were taking on, and some of it wasn't the easiest to repay. I mean, the revenue streams don't necessarily always even out. The state gave us a break and basically created UH as a new state-controlled instrumentality. So UH is now its own state instrumentality.
And there's never any kind of plan to, because it is still, even, 12 or 11 years into this, it's still a big, I deal with the ECROF report and
Yeah.
the whole annual review of the
Yeah.
space inventory, which is constantly evolving and becoming more difficult to
Yep.
monitor as people change over and time goes in. And I know that, when did that lease expire? Or that is-
2049, the master lease?
Yeah, so this is another interesting fact. So UMDNJ's campus in Newark was owned by the state, and it was ground leased to UMDNJ under this long-term ground lease. And at the time in 2012, when we were negotiating this whole integration, I was like, why don't we just take title? Why does the state need to hold on to title? We should just take that title. But the state wouldn't want to do that, so they amended the ground lease, which is basically the state owns title, but UMDNJ, you operate it, you build on it, you do everything you need to do on it. So at the end of a ground lease, basically, the tenant, if you don't get it extended, either has to walk away from all their stuff or they extend it. And so in that case, they amended the ground lease, and any of the assets that came to Rutgers are now sort of a direct ground lease between the state and Rutgers, and anything that was left with UH is now direct ground lease between the state and UH. So, and that is a problem. It's it's confusing, and we have a lot of subleases back and forth, and there could be a better way to deal with it. I think some of it is based on anti-kickback issues because we are separate instrumentalities and Stark issues, but that's something that I would argue should be looked at, and there's got to be a better way to deal with it.
That's what my question.
Yeah.
Is there any kind of plan or?
There's no plan that I know of, but it doesn't mean there shouldn't be, and we should, we could push for one, and it's on the priority list of things that are important. Like, I don't know where it would fall, but it is something that one day should probably be looked at, I would say. Frank, you had a question a while ago.
Yeah.
Thanks, Rob, for the presentation. I have 3 questions. So the first one is, how common is the designation instrumentality of the state? You mentioned it, the Turnpike and Parkway. Are there other instrumentalities?
There are, and it's fairly common, but I don't have a sense of how many there are. But those two are another good examples. I'm sure there's others.
Yes.
They are
They're corporations, so they're on.
they may be, yeah. I think that's right.
And I'll share this. I'll give it to Liz. A list of authorities, agencies, and instrumentalities of the state. I don't know why I looked it up once. There it was. But
Agencies are true state. I mean, it's just a piece of the state. They break it down into however they organize themselves. But an instrumentality has a little bit more authority. They usually have their own governing board of some sort, or trustees or something like that. So,
Frank, you had 2 more?
Yeah, so Rutgers v. Piluso. So is that ruling specific to Rutgers University, or can other state universities and colleges take advantage of that?
anyone can take advantage of it. It's case law of New Jersey, so that means it's the same as a statute. Is in a way, it's the law of the state. And in fact, others, what was it, Montclair? They tried to use it recently, and then the Supreme Court, unfortunately, whittled it down the littlest bit. And basically, Montclair, I think, wanted to build a road with a driveway out to a county or a county road, and well, no, was it Montclair? And the county said, no, we're not going to give you the road opening permit to come in. And they said, Rutgers v. Piluso, we're a state, we don't have to. And it went back and forth a lot. And ultimately, the court said, well, yeah, they are state and they are exempt, but because there's safety issues, because of this new driveway thing, they have a little bit more of an obligation to listen in good faith to the locals. Like if there was no safety issues, then basically, unless you're being completely unreasonable, you can do what you want if you're the state. But because when there's safety issues, now you have to be a little more deferential. And we were upset by that ruling because, and that was actually within a few years ago, that you can create a safety issue almost anywhere. If you're a clever arguer, you can come up with some sort of safety issue for anything that you're doing. So that is sort of a little chink in the Piluso armor, unfortunately. But it's still good law, and it's still a strong law, and we do use it a lot.
And the last question is, so we have this two-headed monster, a board of governors and a board of trustees. Unfortunately, they seem to kind of work in lockstep. Are you aware of any instance where the board, either board, kind of worked in opposition to each other?
They can disagree, but they ultimately come around, I think. I think this whole 2012 was a pretty big test. I think the state-controlled BOG was more willing to accept the deal that the governor was pushing. And there was comments from people like Norcross in South Jersey saying, like, all the money from Rutgers Camden goes up the Turnpike. And remember that phrase, the money's going up the Turnpike, which actually wasn't true. Camden actually does require a little bit of centralized support. But wait, what was your question?
Have they ever voted against each other?
They've never voted against each other that I'm aware of, but there was some arguments there where the board of trustees were definitely much more on the side of like the Camden family and the Rutgers family. The board of trustees were being more pragmatic and like, hey, look, we are state instrumentality. We get a lot of money from the state. We don't want to make them too angry, but ultimately, again, the trustees prevailed. And there was some heavy duty arguments in Wynantall back at that day that I remember. So.
Prior to 2012, I sat on the alumni for the trustees at NJIT. No power, not the same thing as board of trustees. But there was talks about combining NJIT with Rutgers and making that part of the state institution as well. So I'm just wondering if you know what happened with that, or if it was just a rumor, or what?
I don't. This is sort of the first time hearing of it, so I don't know about it.
At one point along the way, so the integration, the higher ed restructuring that ultimately happened on July 1st, 2013, had a decade more of history. Remember way back?
Yeah.
Right, so over a 12-year span, there was version after version. And at one point, there was the North Jersey University, which would have been Rutgers Newark, NJIT, and UMD-NJ North combined. And then there was the Central University, which is where Rutgers would have kept that name, and it would have gotten the Robert Wood Johnson Medical School and all those stuff in New Brunswick. And then the South Jersey wouldn't be Rutgers, and probably would have gone to Rome. So at one point, there was a mega North University. That was one of the schemes along the way.
Thanks.
Any other questions? Hope you got something out of it.
So I have an observation. So Rob talked a lot about the 56 Act, which is kind of really foundational for us. The 2013 higher ed restructuring really leaves Rutgers in an odd spot in Newark and Camden, right? So this act has the effect of law, right?
It is.
So the act that went into effect on July 1st, 2013 creates physical instances at RBHS Newark that don't comply with the state's construction and fire codes, right? So, because what they did, it compelled a divorce, but you have to live in the same house, right? So we know that there are violations of code created by this thing, so created by this legislation. So we had to go down to Trenton and broker a deal. We, Hospital, Rutgers, and the state, were down at DCA to kind of make this work. Very clumsy, very clumsy. And in Camden, I think it was out of spite, Christie and the law created a joint board down there, right? So there's this thing called the Rowan University, Rutgers University, Camden Joint Board.
Yeah.
So it's not the Board of Trustees, it's not the Board of Governors, but it has funding, influence, and authority on things that happen in Camden, limited to med ed, right? So I'm making up if the business school in Camden wanted to expand, that's BOG of Rutgers.
Mm-hmm.
If the nursing school down there wanted to expand, that joint board would have its clause in it. despite governors having jurisdiction as well. So it's really
Yeah.
clumsy and odd in both
Is
Newark
that-
and Camden.
Yeah.
Is that why the school of nursing down in Camden is still a separate entity, because they wanted to keep it?
I have RBHS.
Yeah.
Right.
It's another interesting fact. I mean, there was a lot of commentary in the 2012 era about the governance of Rutgers being clumsy, and there's these two boards, and that the state was angry about it because the board of trustees was so big and they couldn't control it, and so they were like mouthing off about it. But the what resulted from the act, which blows my mind, because the very people who were complaining about the governance at Rutgers being unwieldy went on to create a campus board in Newark, a campus board in New Brunswick, and the board of directors in Camden. Those are three new Rutgers governmental like things that now exist under this act, and we deal with them. And so the Camden board of directors is actually a public body, and they actually have public meetings. And they, under the law, they have a lot of similar powers that the board of governors does, except for the few key carve-outs. But basically, everything goes back to the board of governors. So it's just weird. It was like sausage making. It was a negotiation. It doesn't really make any sense though. But it still exists today. And I think the New Brunswick governing board got convened a couple times. There's a bunch of people from the city that were supposed to be on it in New Brunswick, and a bunch of other community members. My understanding is that they met a few times and never have again. The one in Newark, actually, I believe is fairly active. And it's, again, there's community members on it. There's Rutgers, Newark people on it. And that board actually does meet. They don't have a lot of authority, but they can meet and talk about things, and they can advocate for stuff. So that's okay. I guess okay with that. But it's kind of interesting that the complaints about the Rutgers governance ended up making it more unwieldy. So where are we at? 12:54.
Good. Any last question? All right, so Rob, thanks for doing this. I hope everybody found this interesting, right? Continuing the why we are, who we are, and what we are, and very different from the physical, but really interesting. So thanks, Robert.
Yep.
Appreciate it.
And I will send Liz. I'll send you the stuff.